Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk, the most fact-driven, unbiased, true crime channel on the entire internet. Happy New Year, and welcome to our first broadcast of the year. Let's get straight to the docket. First, there was a brief hearing for Lori Vallow this morning. I'll give you my thoughts. Second, the police chief in Columbus says the officer's actions were simply not defensible. Third, an early contender for this year's Mother of the Year award. Fourth, motion in limines were filed in the Ahmed Arberry case. I'll explain. A pharmacist has been charged for intentionally destroying the vaccine. And finally, our dumb criminal contestant of the day, our first for 2021. Let's talk about it. Good day, Crime Talk aficionados. My name is Scott Reisch, and this is Crime Talk. Welcome to our first broadcast of the year. Now, let's get straight to it. If you haven't done so already, please hit that subscribe button as well as that little bell so that you receive notifications of when we go live or put up new content. And we will be going live tomorrow night at 6 p.m. Mountain Time on both Facebook as well as YouTube, so please join us. First on the docket, there was a hearing for Lori Vallow this morning. She decided it wasn't worth her time to show up, but frankly, it was a scheduling matter, so it's not really that big of a deal. You may be saying, why was Chad Daybell, Lori Vallow's husband, not there for the same hearing? Well, this was Lori Vallow's first case. Remember the one where she was charged with abandoning her children, which started out as a felony case, and she faced up to 14 years for the abandonment charges? And then the prosecutor dismissed those charges based upon the new filing where Lori Vallow and Chad Daybell are charged as it relates to basically destruction and tampering with evidence related to JJ and Ty Lee. In the hearing today, basically it's a misdemeanor case. In this particular case, Lori Vallow, under the amended complaint, is simply charged with resisting or obstruction, which is a misdemeanor that carries up to 1 year in jail. She has solicitation, where basically she requested Melanie Gibb to engage in conduct which would constitute the crime of resisting and or obstructing an officer by requesting that Melanie Gibb give false information. And that too is a misdemeanor and carries up to 6 months of jail, as well as the contempt charge, which carries up to 6 months in jail. So in the big picture, not that serious of a case as cases go, particularly when you're facing 5 counts on each count of the concealment counts in the felony matter. This case was scheduled to start in late January, but a couple of things have come up, right? The felony case has been continued. In fact, we have a motions hearing set on January 6th, which is Wednesday. We will bring it to you live, and I hope to be able to do real-time kind of analysis as we've done in the past, and I'll get to my thoughts on that in just a second. And then the Idaho Supreme Court has basically said there will be no jury trials because of the COVID-19 pandemic, and that hopefully will be resolved sometime by early summer. I can tell you where I practice. Yep, that's right. We're getting further extensions. First, there were going to be no jury trials until February. Now we're all the way into March, and it just keeps pushing back cases farther and farther and farther. Eventually, someone is going to win an argument that is a violation of speedy trial. Needless to say, neither side really wants to do this case that quickly, even though it would be rather quick, but is now set to commence on August 30th of 2021. Now, my big takeaway as it came from this hearing, and it was done on Zoom. Now, you can go to the link below and you can actually see the hearing. And it's kind of weird. There wasn't any audio at the beginning and it kind of re-loops at the end. But that's not us. That was their Zoom call, but we brought it to you the way basically we have it. So there you go. But what is interesting, and maybe it's just me, maybe I'm just reading too much into this, but was it just me or did Mark Means not really look straight into the camera at any given time. Why is that? Maybe it's because Mr. Wood was on the other side of that. And guess what? As I've told you before, I think Mr. Means was out of line for actually accusing Mr. Wood of doing unethical things, tampering with witnesses, and accusing him of committing crimes. You don't do that, okay? It's unethical, and on top of that, you better be able to back it up. I don't think Means has the ability to back this up. And so maybe it was just me, but I didn't see a whole lot of direct eye contact with the camera. Maybe it was just the position. Maybe it's just me, but that's what I saw of it. And the other thing is, if Mr. Wood is such a terrible prosecutor going around committing crimes and should be removed from the felony case, why isn't Means jumping up and down to disqualify him in this case as well? You can't say you can't be the prosecutor over here and be the prosecutor in this particular case where maybe I like you as a prosecutor. It doesn't work that way. Once again, we will see on Wednesday what evidence Means calls to present and support his allegations of witness tampering against Mr. Woods. I personally think this is going nowhere. The court probably figures we have to have a hearing to flush this out, to make any appellate record for the defense. But let's face it, if there was something on its face that would have required Mr. Woods to recuse himself, to be removed from this particular case or any case involving Lori Vallow, the judge would have done it already. There's no basis for it, and I think Mark Means is going to walk away with his tail between his legs. I guess we'll find out Wednesday who was correct. We'll just have to wait and see. Now, next on the docket, last week we brought you the story regarding Andre Hill. This gentleman was in his garage, his car, and apparently a neighbor thought it was unusual that Mr. Hill was in his car starting it up and turning it off occasionally. Not illegal conduct whatsoever. Needless to say, this kind of busybody neighbor, maybe just being a good neighbor, I guess you'll have to decide. Anyway, calls the police. The police arrive. Mr. Hill comes out of the garage area, out of the car. He has his cell phone in his hand. The phone is lit up, and the officers shoot Mr. Hill. He passes away. The police chief for the Columbus Police Department, Chief Thomas Quinlan, said in a video Thursday that the Columbus police officer is responsible for the death of Mr. Hill. He states further, "I cannot defend it, I can't make it right, but I'm going to do what I can do within my power." The newly released body cam footage shows the fatal shooting of Hill. What's disturbing to many people, including the police chief, was that Mr. Hill did not receive medical aid for at least 5 minutes after the shooting. The police chief said that the Columbus Police Department is also investigating whether any of the numerous officers on the scene followed the appropriate protocols. The officer who did the shooting, an officer Adam Coy, was fired last week. Needless to say, Benjamin Crump, who seems to be showing up everywhere these days and is the attorney for Hill's family, said it's a good start. But guess what, Columbus? My guess is for a good finish, you're going to be writing a significant check. Just as a barometer in this particular circumstance, obviously the Breonna Taylor matter warranted a $12 million check to Breonna Taylor's family. This one may be just about as large. And this, ladies and gentlemen, is why we want good police officers out there. Why? Bad police officers are expensive, not just to the police department. That's right, to the citizens. Not only to the citizens that they do wrong things to, but they're expensive to pay for their willful and wanton actions, no doubt. So just another reason why we need good police officers. Now, next on the docket, we have an early contender, and it is early of 2021 here, but we have a contender for the Mother of the Year award. That's right. Please meet Sylvia King. She apparently thought that it would be a good idea to go out and celebrate New Year's Eve. Wouldn't you? We all wanted to go out. Some of us couldn't, because, example, in the state of Colorado, you can't have any fun like that. All bars were told to shut down by 8 p.m. All bars and restaurants can't do any indoor dining. Well, at least until today, even though the numbers are still the same, but apparently somebody figured out, hey, we're not getting any tax revenue from any of these establishments. We need to get back to work. It's always about the money. Remember that? The 12 undeniable truths from a criminal defense attorney? Check out the link. That's right. It's always about the money. Needless to say, Sylvia King faces child neglect, public intoxication, and disorderly charges. You say, how could she possibly get child neglect charges if she just went out to celebrate New Year's Eve? Well, that's right. She took her 1-year-old child with her to a bar and left the child in the car in front of the bar in downtown Chattanooga. Now, Miss King is 25. I guess, you can say she just really didn't appreciate what was going on, but that's what happens when you have a young child. That's right. Your life forever changes. Needless to say, a bystander called the police about the child, obviously thinking the child was locked in the car by themselves. And the police arrived. They went to the bar, made an announcement to ask that the owner of the vehicle come to the front. Needless to say, Miss King did not immediately come forward. Ultimately, the police waited outside and Miss King came out. And guess what? She was observed to have slurred speech and her eyes were glossy and red. She also appeared to be very disorganized and became irate when the police began to speak with her. According to the police affidavit, Miss King would not calm down, so ultimately they arrested her, and the grandmother came to pick up the child at the scene. The child is apparently doing fine, and Miss King was booked into the jail, where it's unclear whether she has actually made bond. But Miss King, one way to get the year off on the negative foot is being arrested and putting your child in danger. There's things called babysitters. Maybe the babysitter fell through, but guess what? Sometimes things don't always work out in life, particularly when it comes to taking priorities of your children. This year, we're still going to be talking with you about CrimeTalkSearch.com. Let's say you wanted to get involved with Miss King in the future. Would you like to know whether she has any arrests? You probably would. Please go to CrimeTalkSearch.com, sign up for a background subscription service. You'll be happy you did. If there's anyone out there you were ever curious about what was in their background, now is the time to do it. If you're going to get involved with somebody, now is the time to do it. When you go to CrimeTalkSearch.com, you put in the name, literally millions of public records are searched, and a report is generated. And it's going to give you a report that's going to give you this person's social media information. If they have multiple social media accounts, you're going to find it. If they have multiple phone numbers, multiple email addresses, it's going to be found. And more importantly, you're going to get information regarding criminal history. Hopefully the person you're searching has none whatsoever. But if it's there, it's going to be found. You're going to get everything you'd want to know, whether you're going into business or whether you're going into a personal relationship. You're going to be able to find out the information you want to know. So go to CrimeTalkSearch.com, sign up today. You'll be happy you did. Next on the docket, the Ahmed Arberry case. We are very familiar with the Ahmed Arberry case. We've talked about it extensively. We've talked about why the defenses that are coming forward by the defense are simply not going to work because we've pulled the Georgia statutes, and it appears as though the defense, if they were trying to do some citizen's arrest, simply doesn't apply. And given the fact from the preliminary hearing that literally Mr. Arberry was chased down and shot, it's simply also going to show that self-defense isn't going to play very well either. Well, needless to say, the defendants are filing motions in this case. Now, you have motions where you say, hey, judge, suppress this statement. Don't allow this to come in. It'll result in an unfair trial. Usually it's a motion to suppress. Something was obtained illegally, searched, or a statement by a defendant was obtained illegally. Then you have what they refer to as motions in limine. And motions in limine are things that you tell the judge or ask the judge to say, this evidence shouldn't come in. And a couple of motions in limine that were filed on behalf of Travis McMichael in this particular case is that they don't want Mr. Arberry referred to as a victim until ultimately there is a conviction, if there is a conviction at all. Now, this became really popular years ago in guess which case? The Kobe Bryant case. Attorney Pamela Mackey said, hey, you can't refer to the victim as a victim. She's nothing more than a complaining witness. Now, that's been litigated. It has actually gone up to several courts, the Supreme Court here in Colorado, and they say, no, you can refer to them as a victim, even though they haven't been found guilty. The defendant hasn't been found guilty of anything yet. But it's language that you can use. Sometimes you want the person to be a victim. Sometimes you want to be sympathetic towards them from the defense side. Here in this particular case, the attorneys for Mr. McMichael are saying, we don't want him referred to as a victim. I think the judge is going to deny this motion and probably state that that's the way the legislature drafted various statutes, and that will come in. Another motion in limine that Mr. McMichael's would like to have granted is that basically there not be a family photo or a family member basically get up and say that Mr. Ahmed Arberry was in fact a live human being. You may think that sounds weird, but why does that take place? Well, one of the elements of the case obviously is that somebody has passed away. So you kind of have to say that this is in fact the person that we say it is. Oftentimes district attorneys will have a family member or a detective identify. Usually it's not a big deal. Parties will stipulate to it. But sometimes in very emotional cases, the prosecutor will want a family member to get up and introduce and identify a photograph of the deceased. Now, in this particular case, the defense counsel says no family photos because the identification could cause an outburst and will be extremely prejudicial. The defense wants just one photo and it'd be introduced via a third party, usually a police officer, not in fact the family. Now, when we've talked about motions in limine, it doesn't mean that it's not admissible evidence, and we've talked about this, and sometimes this gets a little too far in the weeds, but you have evidence that is relevant. What element does it go to prove in the case? And a lot of people get wrapped around the axle. Well, there's all these theories over here and this and that. No, if it doesn't go to prove or disprove an element in the charge, that on or about the date and place charged, the defendant took the life of another human being without legal permission or justification. Pretty general, right? But you'd be surprised how many tangents people want to get off on, and it's simply not relevant. But then you have evidence that's relevant, but it's so prejudicial that it will result in an unfair trial. And that's what the defense is saying here, saying, hey, judge, go take a look at our Rule 403, that evidence can be excluded because although it's relevant, its prejudicial value far outweighs any probative value whatsoever. So, judge, we concede they're allowed a picture. We think it should be one person or a single photo, not a family photo with Mr. Arberry, and it should be done through a third party. This comes up a lot in homicide cases, particularly when you have either a crime scene or you have an autopsy. Oftentimes you say, judge, I get it. You're going to show a couple of pictures. We're saying that no more than 3 should be shown. And sometimes judges will say, hey, it's a murder case. They're coming in. Other judges will say, hey, district attorney, pick your 5 best photos. I want to take a look at them and we'll see how they come in. We're here to try a case. We're not here to inflame the passions of the jury by showing them photographs. Understand, I could literally eat my lunch looking at autopsy photos, but to some people on the jury, it could be rather disturbing, particularly if they're not used to it. I've talked to jurors afterwards and literally after homicide trials, and they literally have said, I need counseling. I think I have PTSD based upon what I've seen and what I've heard. So that's why that rule is there. The other ruling that the court is being asked to resolve at the request of the defense is that nobody be allowed in the courtroom with Black Lives Matter face masks on for anyone. Now, that's going to be a little tougher for the court. Now, certainly the court can make rules regarding the decorum in the courtroom, but here you have a public courtroom, and you get into people's First Amendment rights as well. Judge is going to have a tough decision to make on that particular ruling, but I think the court will probably agree with that simply because we want to maintain any decorum in the courtroom and simply to protect the rights of the defendants in this particular case. I think that the judge will ultimately rule in favor of the defense on this particular matter, not because the judge has anything against Black Lives Matter. I don't know how they feel, but I think that the court will use its discretion regarding decorum in the courtroom, and just to avoid any issues, try to limit that so that it's basically not an issue in the future. If the court denies it and everybody shows up with Black Lives Matters on their masks, it could be an appellate issue for the defense if there is in fact a conviction. We'll see how the court rules on those matters shortly. Now, next on the docket, obviously there's been a lot of talk lately about the vaccine for COVID-19 and getting it out to lots and lots of people, right? So that we can all get back to work as normal. Well, there is a case out of Wisconsin where a pharmacist allegedly sabotaged more than 500 doses of the Moderna vaccine. Apparently, the hospital originally thought that the incident was an accident, but the Aurora Health said that they discovered that the pharmacist did this on purpose. The now former employee in question allegedly admitted in writing that he left out the vaccine on purpose, knowing that improperly storing the vaccines would result it to be ruined. Detectives suggested that the defendant knew that spoiled vaccinations would be useless and that people who got them would think they were vaccinated when they actually were not. Those some 57 doses that were destroyed cost the hospital between $8,000 and $11,000. Now, the pharmacist, and obviously I'm always suspect when the police say somebody confessed, we give them the presumption of innocence. The pharmacist who's in custody is a gentleman by the name of Stephen Brandenburg. And most pharmacists are usually pretty smart, so hopefully it was a mistake. You hope they're not going around harming people. But if he did it intentionally, it's certainly at most damaging and destruction of this particular property. Fortunately, he didn't do anything that harmed anyone, and apparently none of the spoiled vaccinations were given to anybody. You just can't make this stuff up, ladies and gentlemen. No reason as to why he would have intentionally destroyed the vaccinations. You just can't make this stuff up, ladies and gentlemen, and no reason as to why he would have intentionally wanted to make these vaccinations completely ineffective. Next on the dumb criminal contestant of the day. That's right. A whole new slate has been started here in 2021. Well, please meet Caleb Bezurek. He's 29, and apparently he really wanted his old employer to become friends with him on Facebook. When Mr. Bezurek didn't receive a prompt response from his former employer, he became somewhat upset. And he began sending very menacing messages, including ones which said, "Accept my friend request or I'm going to murder you." That's right. That's not exactly the way to get off on a good foot. You would think something like, "Hey, it'd be nice to catch up with you. Please accept my friend request. Hey, you live an interesting life. Please accept my friend request." Not threatening to do harm with anyone. That usually causes people to contact the police. So Mr. Bezurek You are our dumb criminal contestant of the day because, yes, that's right, you got arrested on felony counts of terrorizing in connection with this little incident. Congratulations. You may not be the dumb criminal contestant of the week, but you're the first dumb criminal contestant of the year. Now, what would the dumb criminal contestant get if they win the prize at the end of the week? Well, let me know. Do you think they should still get a mug? Do you think we should give them something else? You let me know in the comments below. We're always looking for new ideas. Needless to say, a mug certainly can't help Mr. Berserk get out of his little situation, but maybe it'll bring a little solace to him when he can sit there and look at his ankle monitor and maybe have a cup of joe and think, hey, things aren't all that bad. I do have this mug. All right, that's all we have for you today. Make sure you check back tomorrow, and we will go live tomorrow at 6 p.m. And do not forget, on Wednesday, we will be covering the hearing in the Chad Daybell Lori Vallow matter live. Look forward to seeing you at that time. Have a wonderful day. Happy New Year, and we'll see you next time on Crime Talk.